Well, I hope the microphone is on. It obviously is. Welcome to this second in the series of annual public lectures on different aspects of legal history. They're organised by the Selden Society and the Four Inns of Court in London. For those who may not know, the Selden Society is not a group dedicated to the study of John Selden. The Selden Society was founded under the aegis of the great 19th century scholar F.W. Maitland in 1887 to encourage the study and advance of knowledge of legal history. It's a great pleasure to have a live audience here. We haven't seen a live audience for rather a long time. But it's also a tremendous pleasure to know that this talk is live streaming to hundreds of people around the world. And it is a remarkable benefit of what's been happening in recent times. Before introducing our speaker this evening, I should say that we're recording this talk and that it will be available on the Inner Temple YouTube channel and website. At the end of the talk, there will be a short time for questions. There will be roving mics, and no matter how sonorous your voice may be within the church, I would be grateful if you use the mic, because otherwise the people listening online won't be able to hear what the question is. This evening, our speaker probably needs no introduction to those who are in the room. That is Professor Sir John Baker. We are delighted that Professor Baker is here to talk to us. The list of his academic honours and achievements is far too long for me to repeat. It's worth repeating, however, that he is the immediate past president of the Selden Society and a bencher of the Inner Temple. His subject this evening is John Selden, who is one of our benchers, or was one of our benchers, and a leading figure in the legal, political, and philosophical world of his time. He lived a long life, from 1584 to 1654. His reputation went far beyond these shores, although he never did. He was a towering figure in his day, moving in the intellectual circles which included such people as Ben Jonson, the dramatist, Thomas Hobbes, the philosopher. In Parliament, he worked with Sir Edward Coke, another bencher of the Inner Temple. He worked with him on the Petition of Right, which remains one of the cornerstones of our Constitution, and indeed it has been cited in support of the Third and Seventh Amendments of the United States Constitution. Selden's memorial was in this church until the bombing of 1941. During the preparation of this talk, I've somewhat irreverently referred to it as the Over My Dead Body talk. That's because Selden is actually buried in this church. And as you go out to the south door, you'll see illuminated under a glass panel his tomb. Selden has long been a matter of interest to many of us, and most of us don't know as much about him as we should. And this evening, I hope, is going to be a correction of that deficiency. Let me ask then, Sir John, tell us about, if you would, Selden's origins.
Well, they were modest. His father was a yeoman farmer and a part-time minstrel. He was born and brought up in a cottage, a thatched cottage at Salvington near Worthing in Sussex, which was preserved until it burned down in the 1950s. He was certainly self-conscious about his humble origins, and on the monument which Master Cryan mentioned, which I think used to be over there until 1941, there was an epitaph which he composed himself, in which he claimed to hail from a knightly family, and he was alluding to his mother's rather tenuous kinship with the first Sir John Baker, who was a bencher of the Inner Temple in the mid-16th century, and whose arms Selden adopted with a very slight variation, and they were on the monument, but alas, no more. But his lowly origins in no way diminished the impact he made, the reputation which he had amongst contemporaries. He was revered, in the words of John Milton, as the chief of learned men reputed in this land. Another said that what Selden didn't know, no one knew. His fame is undiminished today, at any rate among scholars. Several of his books are still in print, and 9 books have been written about Selden, on my count, in the last 30 years or so. One of his principal claims to fame, of course, and the reason why the Selden Society chose him as their eponymous hero, was that he raised the study of English legal history to new heights.
Well, obviously, before Selden, there were those who had written on the law in earlier periods. But was there, in fact, any formal study of legal history before in that period, in the Tudor and Jacobean times?
No, there wasn't. The universities were still run by and for the clergy, and they didn't condescend to teach English law or English history. There was an informal society of antiquaries in London, but its very existence was disliked by James I, who feared, quite correctly, that its activities might well have political implications, and he denied it a charter, and it fizzled out around 1607.
I believe Selden went to the local grammar school at Chichester, but what happened after that?
Well, somehow or other, money was found for him to go to Oxford for a relatively short time. Of course, he didn't graduate because only clergy bothered to stay on to graduate. But the Inns of Court were the intellectual milieu for men with wider interests, and somehow the money was found for Selden to go on to Clifford's Inn, which was one of the satellite Inns of Chancery belonging to the Inner Temple. And from there he went on to the Inner Temple, where he was duly called to the bar in 1612. And he kept chambers in the inn on the site of what is now Paper Buildings for the rest of his life.
But did his career follow a conventional legal path?
Not entirely. His name doesn't appear in the law reports, except in one case that we'll come to later. He made an income from written work in chambers, it seems, and some indication of the level of his practice is that he was counsel to the Virginia Company, helping to settle the colony's constitution. He became legal advisor to the Earl of Kent, whose vast estates the Countess had inherited from the Earl of Shrewsbury. But he showed no interest at all in public advancement. When, in 1624, his turn came to lecture in Lyon's Inn, which was another of the appendages of the Inner Temple, this being the usual step on the ladder of promotion in the law, he obstinately refused and was thereupon disqualified by the inn from ever becoming a bencher. It did him no harm, because within 10 years, the Inner Temple was pleased to elect him to the bench anyway. By then, it was more of an honour for the inn than it was for Selden.
Well, the question is, how did his rise to eminence come about then?
Well, we must go back to the legal history. It isn't known exactly how Selden became infected with his love of history, but I suppose that's true of most historians. It's a congenital disease. Strange to say, there's no evidence that Selden took any part in the Society of Antiquaries, which I mentioned, even though papers were delivered on the kinds of subjects which interested Selden. He was more interested in original research, his principal mentor at first being Sir Robert Cotton, the eminent antiquary, who met the young Selden at a Christmas dinner in Sussex, allegedly while his father was playing in the gallery. And Cotton's house in Palace Yard, Westminster, contained a long library room packed with old books and manuscripts and curiosities. And Selden was in his element there. He delved deep into the treasures and was very soon tempted into print. While he was still a bar student at the age of 24, he published Jani Anglorum Facies Altera, the first history of the early English legal system, ending with Henry II, in other words, the period beyond official legal memory. The preface was tellingly dated from the Inner Temple on Christmas Day, 1610. I just hope he found time for dinner in hall. Perhaps he even wandered into church at some point as well. It was written in the over-elaborate, rambling style which became the hallmark of his writing, not helped by being in Latin. Typical of his many digressions, there's a long excursion on the suitability of women to exercise government. Interesting subject, but not exactly relevant to his theme. I do wonder whether there isn't room for a book on Selden as a feminist. But it showed that Selden already had a discerning approach to historical evidence. He rejected the old myths about a Greco-British origin for English law, stories which, as he put it, were patched up out of bards' songs and poetic fictions taken upon trust. He was skeptical about monkish chronicles. For example, he pointed out that the constitutions of Clarendon, 1164, had been mangled and misreported by Matthew Paris, writing some 70 years later. But he was nevertheless willing to accept the evidence of a whole company of monks, as he put it, if they corroborated each other. And in particular, he was interested in a series of chronicle accounts of the Norman conquest, which, though not contemporary, stated that William I had agreed at a great meeting of his council to confirm the old laws of Edward the Confessor. Now, despite the implication there that William could have changed the law if he chose, Selden here perceived a continuity of law and government from Anglo-Saxon times. He also found more than a hint that English kings, both before and after 1066, had always sought parliamentary approval for changes in the law. It wasn't, of course, called Parliament, but something similar. He admitted, obvious, that the conqueror did add new laws concerning the tenure of land, but the point was that he hadn't overthrown the old English law. This continuity was a matter of great importance at the time. Such old laws as were abrogated, he said, were abrogated not by conquest, but by Parliament, whatever it was called. And a few had continued even to the present day. Of course, it wasn't the law wasn't static. It became more fine-tuned over time. But that didn't argue against its essential continuity. As Selden remarked, just as a ship, by often mending, had no piece of the first materials, yet it remained the same ship.
But might it be perhaps a little too cynical to suggest that this interpretation of history was somewhat casuistic on Selden's part, adopting it consciously or even subconsciously because it supported his own concept of what the English Constitution should say, particularly at slightly controversial times?
Yes, well, I think it might. I mean, Selden's conclusions were essentially the same as had been reached in the Elizabethan period, and a version of the same history had been taught in the Inner Temple Hall as early as 1483 by Morgan Kidwelly. But Selden was now investing it with an authority derived from intensive scholarship, and his research confirmed that the long-received tradition in the legal profession was supported by trustworthy evidence and didn't have to be discarded along with the myths about King Brute and the ancient Greeks. In his next major work, it wasn't his next work, he was writing all the time, but next major work, Titles of Honour, in 1614, also dated from the Inner Temple, Selden turned to biblical and classical history for a supporting political philosophy to go alongside what he'd written about previously. He argued that monarchy could not have preceded democracy. In a state of nature, he concluded, all men were equal, but people had found it inconvenient to be ruled by giddy-headed multitudes, referendums and things, and preferred to submit to a single monarch. Kingship, he concluded, necessarily presupposed a prior popular state or democracy. But since absolute or arbitrary power was as intolerable as unlimited liberty, kings came to govern by laws. He cited all sorts of biblical authority to support this, but of course it was a theory. 2 years later, Selden published an edition of Sir John Fortescue's 15th century treatise in praise of the laws of England, which expounded the principle of limited or constitutional monarchy, and also argued for the continuity of English law from a time long before the conquest.
But in a time when thoughtful men looked to antiquity for the validation of laws and rights, Selden must surely have been aware of the contemporary relevance of what he was arguing for from a historical basis.
He must have been. James I's concept of monarchy, I simplified a bit, but it really depended on kings having preceded parliaments, which were called merely to give advice, and on kings being legally capable of ruling without them. His illustrious predecessor, Elizabeth, had not cared that much for parliaments either, but it was well established that the Queen could not alter the law without Parliament. Now there was a king seemingly with different ideas, a king who didn't at first seem to understand constitutional monarchy as it had been accepted in England. And this was a central issue in the parliaments of 1610 and 1614. So it was potentially dangerous territory for a law student to wander into. And perhaps that's why the first book was veiled in scholarly and almost unreadable Latin.
John, you're one of the leading scholars on Sir Edward Coke. And there is some comparison that could perhaps be made between Coke and Selden in their study of the law. How do you regard them as comparing?
Well, the deployment of historical sources in matters of state, in constitutional matters, was a relatively new phenomenon, I think. It was a major change which only became possible when the public records became more widely available in the later 16th century. And Coke was one of the first lawyers to make extensive use of the Record Office in the Tower of London and of the rolls kept at Westminster, building up a collection of transcripts which he used. As early as 1587, he obtained from the Crown Office a collection of precedents of habeas corpus, and these were the basis of a treatise on Magna Carta, chapter 29, which he wrote in 1604. Those are fairly recent records, but Coke also combed through medieval rolls for useful materials. And those who were arguing against the Crown, Coke was Attorney General at that time, but those who were arguing against the government were also beginning to deploy ancient record evidence. Now, it's been customary among historians to praise Selden's historical method and to denigrate Coke's. But the difference between them has been greatly, and I think wrongly, exaggerated. Before Selden was even born, Coke had been exercised by the question whether the common law predated the conquest. Now, it's true he was guilty of anachronisms, of assuming continuity in the absence of contrary evidence, and at one time he even accepted the brute legends when they were still widely current. On the other hand, he did learn from evidence that came to light. He did recognize the importance of seeking the earliest evidence that could be obtained and the danger of relying on chronicles written long after the event. And so he moved away from those ancient legends when he was better informed. Selden's approach was no different, though he had more time to spend on historical investigation and was generally more careful, perhaps. Selden called his approach synchronism as opposed to anachronism. But even so, he fell into many of the same kinds of errors as Coke. For instance, in the Janus Anglorum, he cited, without a flicker of suspicion, the supposed letter from the 2nd century Pope Eleutherius to the mythical British King Lucius, in which he advised him not to adopt Roman law in Britain. He cited it again in Titles of Honour to show that Britain had the first Christian king in Europe in the 2nd century. It was left to Selden's contemporary, Sir Henry Spelman, to expose the letter as a monkish forgery. And there are several other examples of serious anachronism in Selden's writings. But then historians never get everything right.
But despite some errors, Selden's rise to eminence was obviously connected with his fame and repute in the field of legal history. Should he be seen as a precursor of the academic legal historian of today?
In some ways, but I think the analogy might be misleading. For one thing, there were no relevant paid appointments. And for another thing, perhaps more importantly, legal history was then becoming a core vocational subject of intense practical importance in the real world. The reason for Selden's allusion to the Roman god Janus in the title of his first book was that Janus had two faces, one looking backwards to beginnings and the other looking forwards. And Selden was making the point that history was a continuous story bearing on the present and the future. And the contemporary relevance of history was mentioned as early as 1592 in a lecture which Coke gave in the Inner Temple, in which he complained that the history of English law had become a matter of great danger and still greater difficulty. Now, that was in the golden age of Good Queen Bess. History seemed even more dangerous, perhaps in different ways, under the Stuart monarchy, whereas today's governments fret about tomorrow's headlines, James I and Charles I were far more troubled by the past, discoveries from the past.
Well, did this anxiety of theirs cause any difficulties for Selden?
Well, perhaps not immediately, but he soon discovered the present force of history when he encountered his first clash with the establishment when he published his History of Tithes in 1618.
I must say that sounds like a fairly innocuous subject. How did it prove to be controversial?
Well, the right to tithes was a subject of considerable controversy. The canon law required landowners to give up a tenth of their annual produce to support the rectors of parishes. But many rectories had been appropriated in medieval times to monasteries. And after the dissolution, these rectories, together with the tithes, were granted out to laymen. And a great deal of litigation had ensued, and the boundary between the church jurisdiction and that of the common law courts had become a legal minefield. I think it's easy to understand the resentment of ill-paid vicars and poor farmers at the abuse of an institution which was created to support the parochial clergy. The bishops are also getting hot under the collar because of their jurisdiction, and they maintained that since tithes were due by the express word of God, they couldn't be interfered with by secular law at all. The common lawyers pointed out that lay rectories had become, as they still are to this day, real property protected by statute. Chief Justice Coke had been dragged before the Privy Council in 1608 to debate this issue with King James I in person, who threatened to decide the disputes himself. He said, I know, I've got as much reason as any other man. You judges are just my ministers, but I can decide these problems. Well, Coke managed to warn him off. Of course, there's a famous episode which is depicted very fancifully on the doors of the United States Supreme Court in Washington, a cook barring James I from his court. But the very right to tithes was clouded by layers of historical misunderstanding, and Selden decided to investigate it. His purpose, so he said, was merely to narrate the history and not to dispute the theology. But the underlying premise was that theology operated on a different plane from law and history. The origin of tithes was a matter of historical fact, not of theory. And history showed that tithes had not been paid in the early centuries of the church. And of course, parochial tithes couldn't have been because parishes were not coeval with the church. And Selden collected plenty of evidence to show that early tithing was the result of voluntary offerings, and that it was only from around 1200 that the church began to enforce the payment of parochial tithes and to develop a jurisprudence linking it with divine right. But that, said Selden, must be positive ecclesiastical law, not divine moral law or natural law. There was no reason in natural law why 1/10 should be preferred to 1/11 and so forth. And since the subject matter of tithes was physical property, grain and the like, the right to take them from a landowner could only be a matter of human law. Now, Selden claimed that his book set out the truth of these matters to inform debate and to allow the reader to form his own judgment. Well, I don't know whether he really thought that and really expected there to be no reaction, but the book exploded like a bombshell. The king, who hadn't previously heard of Selden, summoned him on several occasions to engage in earnest scholarly debate with him. The bishops in the Ecclesiastical High Commission summoned him for a dressing down and indeed decided to shut him up. He was forced to acknowledge his error in publishing the book, not error in its content, as he was keen to point out, but his error in publishing facts which might cast doubts on the church's rights. The book was thereupon suppressed. There are actually quite a few copies around dated 1618, but they're nearly all facsimiles printed in 1680. Perhaps even worse than having the book suppressed, Selden was threatened with imprisonment if he was audacious enough to publish any response to the various attacks on his book, which were being rapidly commissioned. So his fingers had been scorched, and he never again published anything quite so controversial. But he discovered the power which history could exercise in the living world. And as he wrote in the preface to his History of Tithes, he hadn't related antiquity to show barely what hath been, but to give other light to the practice and doubts of the present. Because he said the pursuit of bare and sterile history, that is the collection of unconnected facts, was nothing else but to be exceeding busy about nothing, whereas the fruitful and precious part of history gives necessary light to the present. And one's tempted to add that the special power of history, and that the reason why it so incensed the divines and so disturbed kings, was that it could only be countered by better history. And by 1618, Selden had proved himself to be a consummate master of historical detail from the time of Abraham to the present, and his notoriety soon thrust him further into the public sphere. He was about to become the nation's legal historian.
As a legal historian, I assume he soon became an armourer in the battle between Parliament and the establishment. But did he move from there to becoming a warrior in that battle?
Well, he didn't start out as a warrior. In 1621, Selden the historian was engaged by the House of Lords to collect precedents to clarify the privileges of the House in connection with judicature, especially in relation to the revival of impeachment. And at the same time, he was engaged by the House of Commons to collect precedents in support of their protestation touching freedom of speech. And the result was that the king thought him troublesome and had him arrested. He was soon released without charge. Don't know what the charge would have been, but it was perhaps the call to arms. This was a law-abiding barrister who'd been locked up with no reason given. Selden didn't know what the reason was, seemingly just for doing historical research. And if it was meant to silence him, it was very ill-judged indeed, because it had the opposite effect. It began a 7-year involvement with the subject of liberty. And Selden was now a public figure. At the next general election in 1624, he became a member of Parliament and was immediately in demand to serve on committees, draft bills, search for precedents, and so on. He began to master the records of Parliament and became a stout defender of the Commons. His first speech in the 1626 Parliament was made on behalf of Sir Edward Coke, who'd been appointed Sheriff of Buckinghamshire against his will to prevent him taking up his seat in the Commons. And Selden produced an argument which was legally ingenious, but perhaps historically less than sound. He spoke on numerous other constitutional matters, usually producing strings of precedents which no one else knew about, and on which he couldn't therefore be challenged. Most of all, he was closely involved in the impeachment of the Duke of Buckingham, the King's leading minister and favourite, and helped to present the case in the Lords.
Well, by that time, it would seem that Selden had become a man with a mission in the real world. Did he avoid the temptation to spin history and to distort his learning?
Well, the intellectual difficulty for a historian who becomes in real-life affairs in a world where history matters is obviously to distinguish between the historian's impartial search for truth and the lawyer's search for a viable argument. The advocate represents a party, whereas the historian forms a judgment. And I suppose you could say the advocate is, in this context, arguing about law, whereas the historian is arguing about fact. But the difficulty is especially acute for someone who knows much more than everyone else, because there must be a temptation, not exactly to cheat, but to take advantage of that expert knowledge. It was around 1619 that Selden adopted the Greek motto which is used on the Selden Society's half-titles, which translates as liberty above all things. Now, whether this meant that liberty was above historical impartiality was a question on which Selden was about to be tested. He
used his historical learning in Parliament, but did he also deploy it in court?
In court? Well, he did briefly and notably, but not very successfully. There was an interruption in his parliamentary career when Charles I dissolved the 1626 Parliament after only 4 months, partly to save Buckingham, and partly because it failed to grant him the money he wanted without unacceptable conditions. And in exasperation, he told the Privy Council that he abominated the very name of Parliament. He decided to make do without it and to raise funds by means of forced loans. Never mind that the lenders were unlikely to see their money again. Anyone who declined to pay would be locked up. The king asked the judges to confirm the legality of this wheeze, but to their credit, they refused to do so. Lord Chief Justice Crewe was thereupon dismissed, following the precedent of Coke, who had been dismissed in 1616, the sort of thing that hadn't happened before. And about 70 loan refusers were arrested. There was no intention of bringing them to trial because the judges were very unlikely to uphold the government. But in June of 1627, 5 of those imprisoned, known to history as the 5 Knights, took the initiative themselves by applying to the King's Bench for writs of habeas corpus. The Privy Council was duly alarmed and directed that the returns, that is, the formal explanations for their detention, should state merely that the 5 Knights had been detained by the king's special command. This was calculated to prevent any argument about the legality of forced loans, because the only question it raised for the court, the two questions really, was this a good return, and could the court grant bail? Each of the 5 knights was separately represented, and Selden was assigned to represent Sir Edmund Hampden, who was an Inner Templar, not to be confused with his nephew John Hampden, also an Inner Templar, who contested ship money in the 1630s. And no doubt it was hoped that Selden would introduce some helpful history, but in truth there wasn't that much available that was very helpful, and Selden could add little to the points already made by William Noy, representing Sir Walter Earle. Selden began by objecting that the return addressed only the detention, not the initial arrest. But this was a formal quibble of rather doubtful merit. His main argument was based on Chapter 29 of Magna Carta, no free man shall be imprisoned except by the law of the land, etc. If this was duly executed, he said, every man would enjoy his liberty more than now they do. Admittedly, the law of the land was a flexible phrase, he said, which taken alone might include arbitrary imprisonment by the king. But it had been explained in 14th century statutes as requiring due process of law. That meant, in Selden's submission, a formal accusation by presentment or indictment. Then he moved on to a discovery of his. Chapter 29 of Magna Carta also contained the phrase, nec super eum mittemus, nor shall we send upon him. These words, said Selden, might not signify much. Indeed, a man cannot find any fit sense for them. But in the Chronicle of Matthew Paris, printed in 1571, which he said was very authentic, since Paris was the king's chronologer, could be found what Selden claimed to be the text of King John's charter. And this read, nec in carcerem mittemus, nor shall we send him to prison. And since the Charter of 1225 was then thought to be merely a reissue, this could be taken as clarifying the original intent. And the first person we in that clause emphasized that the clause referred to imprisonment by the king. And if the king could imprison free men at will, they would be in no better position than villeins. And then the no free man provision would be self-contradictory, so that couldn't be right. This, again, it has to be said, was a somewhat artificial argument, since the king no longer had any villeins, but it was a legal argument. The Crown was represented with consummate skill by Robert Heath, the Attorney General, and another bencher of the Inner Temple. He features rather a lot in this story. It must be wrong, said Heath, to argue that one could only lawfully be imprisoned, one could not lawfully be imprisoned without presentment or indictment, because it happened every day when constables arrested suspects of felony, or when magistrates committed accused persons for trial. Heath agreed unreservedly that Magna Carta was fundamental, wasn't going to fight that, but he challenged Selden's submission about the wording. And if I may, I'll just quote a bit of Heath's argument to give you a taste of it. I cannot judge of the manuscripts that I haven't seen, but my lord, I have one here by me which was written many years ago, and the words in print are word for word as that which is here written. Then they say that Matthew Paris set it down so in his chronicle. My lord, we don't govern ourselves by chronicle, but I have looked into Matthew Paris, and it there appears that in the time of King John there were articles made to the effect of Magna Carta, but in many particulars differing from it. So it seemeth that it was but an inception in the time of King John, and it was reduced to an act shortly after in 9 Henry III. He went on to say that it didn't really matter very much anyway, because the words added nothing to no free man shall be imprisoned. He then asked the clerk of the Crown to read out all the statutes of due process, which Selden had cited, one by one, and explained why they were not in point. For instance, they actually said presentment or due process in the disjunctive. It's a rather devastating response. On the other hand, there was direct authority against the 5 knights in the unanimous opinion signed by all the judges in 1592 that someone committed by the Queen's special command was not bailable. This, said Heath, was necessary in matters of state, such as the gunpowder treason. And in such situations, one just had to trust the king. Well, the court accepted Heath's argument and remanded the prisoners without bail. The Lord Chief Justice even hinted that the defendants' counsel had tried to inveigle the court by misrepresenting some of the precedents. It was a resounding defeat for Selden, who was overwhelmingly outgunned by Heath on this occasion. The due process argument had not been thought through properly. I grant that he probably didn't have much time to prepare. Moreover, the Magna Carta of 1215 had never become law and was relevant only as a precursor to the 1225 statute, which Heath stated quite correctly. Had a true copy been available, they would have discovered that the words in carcerem weren't in there anyway. It's probable that Selden had not yet seen a copy of King John's Charter because it was over a year later that Sir Robert Cotton acquired the first of his 2 originals. But what is perhaps telling is that Selden pressed the authority of Matthew Paris, who, you may remember from what I said earlier, he'd castigated in print in Janus Anglorum as an inaccurate monk.
We all fail from time to time. Selden must have had to get used to it. But after his argument failed, what happened next?
The prisoners were released by the King's command on the 2nd of January 1628, and there followed much debate as to whether the case had decided anything. No judgment had been entered, but only an annotation on the roll of the Clerk of the Crown that the prisoners were to be remanded, remittitur. This could mean that bail had been decisively refused, or it could mean that the prisoners were remanded pending a decision on that question. And such ambiguity was normal because habeas corpus enrolments always ended with a procedural rule or an order rather than a definitive judgment with reasons. Now, when a new parliament met in March of 1628, with many of the imprisoned anti-lenders as members, the issue was very much on the agenda, not surprisingly. And having lost in court, Selden was now determined to win the argument in the more receptive arena of the House of Commons. He produced a definitive text of all the historical materials. I think he was stung by the Lord Chief Justice's comment that he might have misled the court. And these materials were entered on the journals of the House of Commons. He revisited all the arguments and dwelt long on a tenuous distinction between the clerical annotations remittitur, let him be remanded, and remittitur quousque, etc., let him be remanded until ... It was an age in which technicality could win cases, but it was, I would suggest, inappropriate and unconvincing here. At the same time as this debate, Selden launched some parallel campaigns, particularly against pressing soldiers, billeting, and the use of martial law in peacetime. Martial law included capital punishment without trial. He was very busy. He was named to around 50 committees, and he made 130 recorded speeches. May well have been more. By April, thanks to Selden and others, the liberty of the subject was dominating the proceedings in Parliament, and a major debate was staged at a joint conference between the Lords and the Commons. Heath led for the Crown, while the opposition was represented by 3 other Inner Templars, Coke, Sir Edward Littleton, and Selden. The underlying issue was only lightly veiled. Everyone knew why the 5 knights had been incarcerated, even though the true reason had been excluded from consideration by the court. The reality was that the king had taken undue advantage of a principle which had always been accepted in the context of pre-trial imprisonment to enable him to force people to hand over money to which he was not entitled. That was an innovation, and it infringed the more sacrosanct principle that taxation could only be imposed by consent of Parliament. It also infringed the principle, which was the real gist of the due process statutes, that no one should be imprisoned indefinitely without trial. If the king didn't have to give reasons for imprisoning people, there were no legal means by which unlawful reasons could ever be challenged. It might even be done to silence political opposition, and both Coke and Selden had experienced that personally, and they knew the despair of losing one's freedom with no reason given and no date set for release. A legislative solution was therefore sought, confirming Magna Carta and the statutes of due process. Heath, on the other hand, urged the need to retain an ultimate prerogative power to imprison without showing cause, relying not only on the judicial decision of 1592, but on a decision by Coke himself as Chief Justice in 1615. Selden retorted that while Heath was speaking for his fee as King's Counsel, the gentleman that spake in behalf of the House of Commons came there bound by the trust reposed in them by their country that sent them. Liberty of the person was the most fundamental right inherited by every free man of the kingdom. And if there was a right, there had to be an effective remedy, because otherwise the right would be vain and meaningless. And remedy, indeed, there was. Habeas corpus, the highest remedy in law, said Selden. There were a dozen precedents, he said, where prisoners committed by the king's special command had been bailed upon habeas corpus. And moreover, there was an express judgment in 1344 that a bare command by the king was not a sufficient cause of detention. Mysteries of state could not prevail over law. Selden also produced a more nuanced interpretation of the 1592 opinion. They had some difficulty finding a text of it, but when they found it, it said that those imprisoned by the Queen's command could not be released by any court without a trial, but that they were nevertheless entitled to be brought into the King's Bench by habeas corpus, and if the return set out the cause for the imprisonment, they would not be released. Very obtuse. It was deliberately obtuse in order to get the Queen to agree to it. But it left it open for Selden to argue that merely reciting the sovereign's command did not amount to setting out the cause. Moreover, the wording clearly presupposed that the prerogative power would be used as a preliminary to jury trial, even if that had not been spelt out. A more disingenuous submission that was made was that the 1615 report of Coke's judgment was the unreliable garbling of a young student, I think almost certainly Henry Rolle of the Inner Temple. Coke, however, who was present, disarmingly confessed that it really was his opinion at the time, but he changed his mind after members of Parliament, including himself, had been imprisoned without known cause. And this, of course, underlined the main point, that a principle accepted as sensible in one context, in 1615 they were still thinking about gunpowder treason and so on, had been grossly abused in another. The outcome of all this, as you will know, was the Petition of Right, which was Coke's idea rather than Selden's. Selden hated compromise, and he would have continued to press for an ordinary act, which he thought would be more effective, even though it wasn't politically achievable. But the petition from both houses, having grudgingly received the royal assent, was effectively a statute. It stands to this day as a guarantee that no one shall be compelled to pay any tax or loan without the consent of Parliament, that no one shall be imprisoned without cause shown, and that no commissions of martial law shall be issued or executed contrary to the law of the land. It therefore achieved all of Selden's goals. Although Coke deserves much of the credit, the victory was certainly due in part to Selden's tenacity and his industrious historical research. Selden was responsible for much of the wording, and his last-minute investigations into manuscripts in the two university libraries helped to avert deadlock in the final stage. Not everyone approved of his efforts. The Earl of Suffolk accused him of taking a course to divide the king and his people and said he deserved to be hanged. Others have said that the mutual distrust between king and parliament, fomented by Selden's opposition, hastened the civil war and the king's execution. But that was a subject on which Selden himself always kept wisely very quiet, and I shall do the same.
Because even the most radical of journals nowadays doesn't seem to suggest we should hang legal historians, I'm pleased to say.
Indeed.
The petition having been secured, did Selden then return to private life and scholarly pursuits?
Not yet. The Parliament of 1628 had not run its course. The Duke of Buckingham has still not been impeached, and Selden helped to draft the remonstrance against him. That project fell through when Buckingham was assassinated during the recess, but Selden returned in the 1629 session to the Petition of Right. The king and the law officers were already playing down its significance, and many instances were discovered in which its terms had seemingly been violated. So Selden wasn't going to take that quietly, and he continued to oppose the government so vigorously that he was seen as dangerous. On the 4th of March 1629, he and 4 other members were committed to the Tower.
But presumably that was under the King's warrant, and what was resulted from that was the same question that had been considered in the Five Knights case.
Yes, indeed, and it was now Selden's turn to make use of habeas corpus. The return this time was slightly more carefully worded than in the case of the Five Knights. It said that he'd been committed for contempt against the king and his government and stirring up sedition. He was represented by Littleton, and he argued, who argued, following drafts which Selden had written for him, that those were not sufficient causes. Contempt against the king was just too vague. Sedition was not an independent offence known to the law at that time. It was always alleged adjectively, as it were. And even if it was not a felony, and no one could be detained for a misdemeanor without bail. Furthermore, for the king to order imprisonment in such a case was contrary to his assent given to the Petition of Right. This speech won much acclaim, and this time it was Heath who was discomfited. Heath was driven to argue that the petition hadn't really altered the law, and that contempt against the king and sedition were sufficient causes of imprisonment. But he didn't have so much authority for that. The judges were not persuaded this time, and they advised the king that it would be wise to avoid judgment by releasing the prisoners. The king, Charles I now, characteristically rejected this advice and had the 5 members transferred from the King's Bench prison back to the Tower with instructions to the lieutenant of the Tower not to bring them back in court. The King's Bench nevertheless granted another habeas corpus anyway, returnable the next term. In the meantime, Selden and 8 other members of Parliament were prosecuted in the Star Chamber for contempt in Parliament in opposing the adjournment. This was the occasion when Speaker Finch had been forcibly held in the chair to prevent adjournment. The defendants argued, Selden and others, that only Parliament had jurisdiction over what transpired in Parliament. That question was referred to all the judges, who, under considerable pressure, rejected the argument, but the majority agreed that it wasn't a matter for the Star Chamber. So that was the end of that prosecution. The following term, back in the King's Bench, the court offered the prisoners bail if they would give sureties for their good behaviour. This apparently was the King's own suggestion. Selden objected that to do that would be in derogation of the Petition of Right. They were entitled to be released without condition. He said, I'll give sureties for good behaviour after I've been bailed, but not as a condition of bail. Well, the court declined this counter-offer, and Selden went back to prison. The roll said simply remittitur, carefully omitting the quousque, etc. Later the same year, I can't help mentioning this, later the same year, Heath was rewarded for his efforts with a grant of all lands in North America between 31 degrees and 36 degrees latitude. Vast territory between what is now Virginia and the Gulf of Mexico, then called Carolina. Selden, on the other hand, was rewarded with imprisonment during the King's pleasure, which lasted until 1631. He did rather better than some of his colleagues who stayed in prison until 1640. Nevertheless, Selden's misfortune made him something of a hero, and that's why the Inner Temple was proud to elect him a bencher in 1633. In 1641, the Commons would vote him a large sum of money in compensation for his sufferings. He had achieved more than most politicians can ever hope to achieve in the real world, and it was not disagreeable to him to return to tranquil scholarship, which he pursued with vigour for another quarter of a century. But that really is another story.
It took the Inner Temple over 60 years to change its mind over Gandhi. In Selden's case, if my maths are right, it took about 8. Do we have any record showing what was the thinking behind this, and in particular, what those such as Heath, who were or had been members of the Inn, were thinking at the time?
I'm not aware of any. Certainly Heath wasn't present when Selden was elected to the bench because he'd gone off to Sergeant's Inn on becoming Chief Justice of the Common Pleas. We know the presiding bencher was the Solicitor General Shelton, and Littleton was also present. All I can say is that Selden had achieved his goals as a Member of Parliament. There were not likely to be any more parliaments for a while in which he could be a nuisance, and so he was slipping into a different mode, as it were. And indeed, to mark the transition, he even helped to stage a royalist masque in the Inner Temple at Christmas 1633.
Summarising is always extremely dangerous in something as complex as this. Might it be right to say that Selden is something of a paradox? On the one hand, a man of steadfast integrity, a courageous champion of parliamentary democracy and the rule of law, a scholar of great knowledge, but on the other hand, possibly a peddler of fake history when it suited, in the same way as some of our politicians now peddle fake news when it suits.
Well, I don't think that would be fair. No, the history was slanted to fit a legal argument rather than fake. But I suggest that Selden should be judged as a historian and scholar by his writings rather than his doings. And the number of recent books about him show that his writings, however impenetrable to most of us, continue to fascinate today. It's true that his legal history proved not to be particularly successful in court, but that wasn't really his fault. It's quite hard to think what else he could have argued. His views on Magna Carta and the liberty of the subject were not original. They were mainstream views shared by almost the whole of the legal profession at the time. His achievement was to clothe them with scholarship and inspire the House of Commons at a critical moment in the nation's constitutional history. It was Selden's appeal to the past, bolstered by a meticulously assembled legal precedents stretching back over many centuries, that gave them the proof they wanted of an ancient English constitution worth fighting for, and he was tireless in urging them on. In that way, he may indeed be said to have lived up to his motto. Without liberty, we shouldn't be remembering John Selden here today. And in that sense, perhaps he was right, that liberty had to come first.
Thank you very much. Now, questions. First of all, we've got some roving mics somewhere over there. Are there any questions, Mr. John? Do we have any online?
No.
Good.
Master Hockman.
Good evening, John. Thank you very much indeed for a fascinating presentation and for putting up so well with the cross-examination. I'd like to ask a rather general question, not specifically related to Selden, but it arises from something which I think you said fairly early on, which was that there was an issue as to whether the common law predated the Norman conquest. Now, I confess that that's not a question that I've ever thought about before, but could you just expand on that a bit? I mean, did it or didn't it, and why does it matter? A 3-minute disquisition will be absolutely fine.
Well, of course, it depends whether you answer the question as a question of law or as a question of fact. It depends what you mean by the common law. Obviously, to legal historians, the answer must be no, because there can't be a common law till you have central royal courts to produce it with professional judges and so forth. But it was a terribly important political point to think of the law as being somehow lost, the origins of the law being lost in the mists of antiquity. Nobody quite knew when, so far back. Because if you once admit that William the Conqueror either changed the law or by his own decision said we could have the common law, then it makes the king superior to the law. And what Coke and Selden and others were terribly keen to prove was that the law was there first, because as Bracton said, it was the law which made the king, not the other way around. And that's why Selden was interested in these accounts of what William actually did soon after 1066, which are probably more or less accurate, but we don't know exactly what happened. That he did apparently say that the laws of Edward the Confessor could be kept. The laws of Edward the Confessor, however, were completely fictitious, because there was no written text called the laws of Edward the Confessor until one was produced long after the conquest. What it meant was the law as it was in 1165, as it were, in Edward the Confessor's day. And of course, it's perfectly true, as Selden said, that many Anglo-Saxon institutions, sheriffs and writs and so forth, did carry on. Well, we still have sheriffs now. That's an Anglo-Saxon institution. So, although obviously they weren't still applying Anglo-Saxon law in 1600 any more than we are now, the argument was an organic one, that there isn't actually any break, that you can just go back into prehistory, and there's nothing to break the continuity.
The online questioning has arrived.
Yes, there's a question that's come all the way from David Nunn in Oklahoma, who sends greetings from Oklahoma, and he asks this: did you say that the clergy went to Oxford but would quit before graduating? Could you clarify or explain, please?
Well, it wasn't necessary to have a degree to be ordained, but by and large, those who stayed on to take an arts degree at Oxford and Cambridge were those who were going into the church, because it was thought to be more useful for them, whereas people like Cook and Bacon all left without a degree, and now that sounds terrible, and you think, goodness, they must have failed their exams, how awful. But most undergraduates who went to the universities in those days didn't intend to stay for more than 2 years or so. They had to they were quite young, of course, much younger than today's students. And if you were going to the Inns of Court, for instance, you would typically go to the university for a couple of years and then go to an Inn of Chancery at the age of 18 and then move on to the Inn of Court at 20 or 21. Whereas if you were going into the church, there wasn't any other formal training beyond university, so you stayed in the university. And if you were quite clever, you might even stay on and take a degree in divinity, but that would take a very long time.
Thank you very much. How far was Selden influenced by contemporary ideas that natural law or divine law might allow a remedy against the abuse of power?
Well, he certainly doesn't deploy them in making arguments, I suspect, because the courts wouldn't have been very interested in hearing arguments based on natural law any more than they would be today, I think. He had to produce precedents and acceptable legal authorities from the past. Of course, he was interested in natural law. He was interested in everything, quite extraordinarily learned in Hebrew literature, for instance, and wrote books on Hebrew law of marriage and goodness knows what else. So he certainly had views on natural law, but I don't think I may be wrong about this, I'm not an expert on his thinking, but I don't believe he thought that you could draw out a viable reason from such things which could be deployed in real life in England, as it were. I think you have to focus a bit more.
Down there, please. Thank you. No, wait a moment, please.
I had the pleasure of being taught by you many, many more years ago than I care to remember, and you brought the plea rolls to life. So we have a lot of young lawyers here today. Dare I ask you, sir, which of his characteristics as a lawyer do you think would be most useful to these young people here today?
Goodness me, I don't think not for me to pontificate on what lawyers should be today. There are many others here who have much more experience of that. And I suppose it's what you might think a legal historian should say they ought to know a bit more about history. And I suppose I do think that, although I'm not sure that we live in different times and people don't think in terms of precedents and getting things right, except sometimes when it comes to the crunch, as with Miller too. They did go back to the 17th century on both sides. And, so sometimes history is thought to be relevant. If they'd gone back to the 16th century, they might have found some more interesting precedents than they actually produced. So I think lawyers ought to know a bit more about history. Selden wasn't an advocate, and the truth is we don't know anything really about his practice in written in chambers, so that one can't draw much in the way of example from his career for a lawyer today, because he only argued this one case in court. It's not quite true. He did, I think, one other. But it wasn't spectacularly successful. And one of the main defense, I think, is that he probably only had a few days to work it out. And any lawyer would have said, well, you've got to rely on Magna Carta. That's obviously the text you go for. And Selden thought, I can add a bit more to that because I read Matthew Paris. You can see how he got there. But that's a rather narrow answer to your question, is that there's nothing in his career which actually helps you to form a model for an advocate today, except that he knew lots of legal history.
But having had the benefit of reading what you were going to say over the last few weeks, it did impress itself on me, John, that one of the things that one took from Selden was a profound belief in the integrity of the law and the courage to stand out to support the rule of law as he thought that it was right. And that courage which lawyers should have to be able to stand there and against self-interest, to the extreme sense that he found himself imprisoned, was something that struck me when I was reading what you had written. And perhaps from a lawyer's point of view, that might be something of an answer to the question.
That's absolutely correct. And I use the same defense that I only had 1 second to prepare my answer to that question. And on further reflection, I adopt Master Cryan's point as well.
We've got another question online.
This is from Francis Bushell, who, Sir John, I gather, is a question from Maura Gellis, I'm so sorry, who was one of your former students.
And Dean of the Archers, yes.
Did Selden have anything to say about the continuity of English ecclesiastical law relative to the Reformation statutes?
Well, I'm sure he says something about them in the History of Tithes. I'm afraid off the top of my head I couldn't say what. He was more concerned with the dissolution of the monasteries than with the break with Rome as such. So that I think, I'm sorry, off the top of my head, Morag, if I may so address you, I don't know the answer. It's certainly not a major feature in his writing as far as I'm aware.
Thank you. How do you think Selden thought about the authority of precedent of what you found in the past? Do you think, is the approach the sort of main tyranny of custom, that once you found a precedent for something, that's simply the law and you have to follow it? Or was he thinking of it more in terms of how do the courts develop?
Yeah, well, that raises again the problem of the difference in approach of the historian and the lawyer, doesn't it? Clearly, as a historian, he obviously recognised that the law is constantly changing and modifying and being adapted. And if you're trying to persuade courts and parliament, then precedent is what you need. And what I think is very interesting about the mindset then is that issues which today we would think would be resolved by political means, it was believed could be resolved by recourse to the past. You can just show that we've never done this. And king after king after king has confirmed Magna Carta. They must be bound by it. You can't depart from it. It's not legally entrenched, but it was certainly entrenched in that sense. And so you could make arguments based on precedent in the past, which probably wouldn't get you very far today, because we don't think in that way of a great continuity. But it was, they weren't being anachronistic, I don't think. That's the point I was making about Cook. They knew things had changed, but they also knew that certain very important things did not change, and that was still believed then.
Thank you. Well, I think it's probably time to draw matters to a close. So John and I have been standing here seeing at the far end of the church tables full of glasses of wine, which you're all invited to take with us at the end of this. But at this point, I'm sure all of you would want me to thank Sir John for this powerfully learned talk, which clearly was the result of great labour and of great learning, not over a short time, but over a lifetime. And those of us who have had the great benefit, even long ago, of being his students, will know what a teacher he is. And so thank you very much, John, for a most interesting and educational evening.
Thank you very much.